It is my great honour and privilege to be asked to moderate this session, and I hope that we'll be able to have an interactive discussion. We have three brilliant speakers who are real experts in this field. Of course, Professor Paul Lemmens, who is the European Court of Human Rights judge, Professor Doğru, who is at Manly University Faculty of Law, Professor of Human Rights, and last but not least, Roisin Pillay, who is the International Commission of Jurists, the Director of the Europe Programme. I intend to say only a few words in relation to introducing this session. Many of you will know that I had the privilege of being Her Majesty's Attorney General in the United Kingdom, and that role is one where guardianship of the rule of law features very highly. And I am deeply privileged to be in the same room of another illustrious law officer, Sir Edward Garnier, who I think I've known since my earliest days at the law, when we were mere pupils together. But we both know that the role of the Attorney General and the Solicitor General in the United Kingdom is a challenging one. I think Sir Francis Bacon described it as the most painfulest place in all the realm, and nothing's changed. I think there was only one Solicitor General who was ever made Prime Minister, and I was reminded this morning by Edward that was Spencer Perceval in 1809, who was assassinated in Central Lobby. And there's been, I think, at least one Solicitor General who committed suicide after doing the job. So you can see how easy and temperate it is. The Attorney General and the Solicitor General in the United Kingdom has three principal roles. The first is to be legal advisor to the Queen, Parliament, and the government. Also, that the attorney is the leader of the bar and superintends all the prosecutorial authorities in the country, as well as being the lead minister for the over 2,000 government legal services officers, which, as Harry Wolff mentioned this morning, are responsible for making sure that there is compliance with the law in government. So that's enough from me. Guardian of the rule of law that was, and you never know, guardian of the rule of law in the future, but as a lay person, as opposed to a government minister. I'm going to go first to my left and ask Rosina to start this session. I hope to keep each speaker on quite tight time limits. I'm going to invite each to speak no more than 15 minutes so that we have an opportunity for questions and debate, and hopefully we'll have a real discussion. So, Roisin, to you first.
Thank you very much. And on behalf of the International Commission of Jurists, I want to thank very much the organisers of this conference for inviting us to participate. And to congratulate them on the excellent organisation, but most importantly on having the foresight and taking the responsibility to organise such an important conference at this critical time. I'm also very privileged to speak in the company of such a distinguished panel. In this presentation, I will try to address issues of the connection between international human rights law and the rule of law, in particular as regards the independence of the judiciary, the role of the prosecution, the role of the legal profession, and the role of civil society, in particular in regard to protection of freedoms of association and assembly. For those of you who do not know the International Commission of Jurists, I should just briefly introduce us. We are an NGO, an international human rights NGO, established in 1952, some time ago now, as a global organization of judges and lawyers with the aim to protect and advance protection of human rights through the rule of law. And so we are extremely interested in the topics being discussed today. Essentially, I want to make two basic points. First of all, that human rights protection is necessary for meaningful protection of the rule of law. Without protection of human rights, the rule of law loses much of its value for individuals in a society. Meaningful protection of the rule of law requires the respect and protection, first of civil and political rights, such as those protected by the European Convention on Human Rights, the International Covenant on Civil and Political Rights, and including rights that allow for participation in public debate, for example. But it also requires protection of economic and social and cultural rights, such as those which states have obligations to protect under the International Covenant on Economic, Social and Cultural Rights. Rights including the right to food, to an adequate standard of living, to healthcare, and to education. These are the conditions of individuals' real participation in a society. And I think that this it links to the very interesting discussion we had yesterday about economic development and the rule of law, the importance of such development for the rule of law. This is also something that we can think of in a human rights law framework. The second point I want to make is that the rule of law, and especially the separation of powers, is in its turn an essential element of the protection of human rights and is essential for the discharge of states' international human rights law obligations. Principles of the separation of powers, of the independence of the judiciary, do not exist simply as privileges for judges. They are instruments to guarantee that the courts provide justice to those seeking to protect their rights and freedoms. And international human rights law recognizes that the rule of law, and in particular an independent judiciary, an effective, impartial prosecution, and a strong and independent legal profession are indispensable for human rights protection. The nature of international human rights law, through treaties such as the European Convention on Human Rights, the International Covenant on Civil and Political Rights, as well as through customary international law, is that it places binding legal obligations on states. But as such, it places obligations on all the institutions of the state, the executive, the legislature, but also the judiciary, the prosecution, and other public authorities. And so the judiciary and the prosecution are therefore essential actors in the protection of human rights in accordance with the state's international obligations. Also, in international law, the state has obligations, not only negative obligations to refrain from actively interfering with human rights in an unjustified way, but also has obligations to take positive measures to protect and fulfill human rights. And this can require the state, first of all, to take measures in law, to put in place the constitutional framework, the legislative framework, the institutions that protect human rights, but also, crucially, in practice, that the laws must be implemented in a way that is effective, that is fair, that is non-discriminatory. The laws must be enforced, and that practical measures must be taken to ensure human rights protection, including practical things such as training in human rights of public authorities and providing guidance on human rights to them. Looking specifically at the role of an independent judiciary in human rights protection, of course, a judiciary is essential to human rights protection in many ways. It's the judiciary that applies international human rights law in its decisions. It upholds the right to a fair hearing, and its judicial vigilance is essential to protecting rights to liberty, to freedom from ill treatment in detention. Also, the judiciary enforces the principles of equal and effective access to justice and the right to an effective remedy for violations of human rights. And as previous speakers have pointed out, the right to a fair hearing in international human rights law also requires the right to a hearing by an independent and impartial court or tribunal. And what this element of the right to a fair hearing requires is first that the executive respects the independence of judges. And the United Nations Human Rights Committee, for example, which is the authoritative body that interprets the International Covenant on Civil and Political Rights, In describing the right to a fair hearing under Article 14 of the Covenant, the committee affirmed that the fairness of proceedings entails the absence of any direct or indirect influence, pressure, intimidation, or intrusion from whatever side and for whatever motive on judicial decisions. But the right to a fair hearing also requires an institutional and legal framework to be in place and that it's implemented in practice for this right to be realised. For a tribunal to be independent so as to satisfy the right to a fair trial, the jurisprudence and comments of international human rights tribunals establish that consideration should be given to the manner of appointment of judges of the court, their term of office, their security of tenure, the conditions governing their promotion, transfer, suspension, and dismissal, the existence of safeguards against external pressure, and the appearance of independence. A further important obligation, and it was mentioned this morning by Judge Caracas, is that there is an obligation under the right to fair trial on the executive to respect the judgments of the courts. And this, of course, is crucial to the rule of law. And has been emphasised inter alia by the European Court of Human Rights, the importance of all state authorities to respect and to abide by the judgments and decisions of the courts, even, and this is the crucial point, even where they do not agree with them. A final point on this aspect of the right to a fair trial is in relation to the extent to which the right can be qualified. And although certain aspects of the right to a fair trial may be qualified in certain respects, it's very important to remember that the core of the right to a fair trial and the independence and impartiality of a court as part of the right to a fair trial is an absolute right from which no derogation is permitted, even in times of emergency. And this has been very clearly stated by the United Nations Human Rights Committee. Also, to keep in mind, a separate aspect of the importance of the right to a fair hearing here, judges have rights to a fair hearing too, and it can be important where there's disciplinary action against a judge. The right to a fair hearing in the determination of the judge's civil rights and obligations in those proceedings can be a safeguard against arbitrary disciplinary action. And this is a question that has arisen in cases before the European Court of Human Rights, which I think some of my colleagues may refer to later. But it has been found, there have been found to be violations of the right to a fair hearing, where a judge has been dismissed through a process that was not sufficiently independent. But also violations of substantive rights of the judge, such as violation of the right to freedom of expression, where a judge was dismissed following comments she made regarding the independence or lack thereof of the judiciary in her country. I want to turn now quickly to the role of prosecutors and their importance in human rights protection. Respect for human rights also presupposes a strong prosecutorial authority in charge of investigating and prosecuting criminal offences with objectivity and impartiality. And the key aspect of international human rights law here is the duty to investigate. Under international human rights law, states have duties to investigate allegations of certain gross violations of human rights, in appropriate cases to bring the perpetrators of those violations to justice, and to provide effective remedies for the victims or their relatives. And these obligations arise, for example, in relation to violations of the right to life, to freedom from torture. And these investigations must be independent, they must be thorough, they must be prompt, and they must be effective. The prosecution service, of course, is essential in safeguarding these rights. An important document on this, which was mentioned by the Special Rapporteur this morning, is the UN Guidelines on the Role of Prosecutors, which recognises the important role of prosecutors in protection of human rights and the duties that prosecutors have in carrying out their functions impartially and objectively. It also places obligations on government to create an environment in which prosecutors can carry out their functions without intimidation, hindrance, harassment, improper interference, or unjustified exposure to civil, penal, or other liability. And a crucial provision in the UN Guidelines on Prosecutors is Guideline 15, which states that prosecutors shall give due attention to the prosecution of crimes committed by public officials, particularly corruption, abuse of power, grave violations of human rights, and other crimes recognized in international law. A third pillar of the criminal justice system, which I want to refer to, is the profession to which many people here in this room belong. It's the legal profession. And I can perhaps address the role of the legal profession in human rights protection succinctly by saying that lawyers are human rights defenders. Even if it doesn't feel every day when a lawyer is working, they may not always feel like they are human rights defenders, but lawyers play an essential role in protection of human rights in many ways, and this is recognized by international human rights law. This law recognizes, for example, the right of effective and confidential access to a lawyer in detention within a reasonable time as an aspect of the right to liberty. The importance of access to a lawyer in detention in order to protect against ill treatment, the right to an effective defense as an element of the right to a fair trial, and the importance of access to justice and the right to an effective remedy, which is also a right which the legal profession contribute to realization of. And these roles and the duties of lawyers to protect human rights are recognized by the United Nations basic principles on the role of lawyers. And it's important that those principles recognize that lawyers have responsibilities to protect human rights. But it also affirms that states have an obligation to support the independence of lawyers arising from this important function that lawyers perform. And they have an obligation to ensure that lawyers are able to perform all of their professional functions without intimidation, hindrance, harassment, or improper interference, and that they are not lawyers are not identified with their clients' causes. If I have another 3 minutes left,
You do indeed.
I want to say very briefly that civil society is also has a significant role to play within a democratic rule of law society, and that this is reflected in international human rights law in the rights to, in particular, freedom of association, assembly, and expression. And international human rights law recognizes the particular importance of these rights in a democratic society. The Human Rights Committee has noted the existence and operation of associations, including those which peacefully promote ideas not necessarily favorably received by the government or the majority of the population, is a cornerstone of a democratic society. The European Court of Human Rights has taken a similar line and has therefore emphasized the principle that only the most convincing and compelling reasons can justify restriction on these freedoms. We also have the United Nations Declaration on Human Rights Defenders, which underlines the importance of participation of everyone in the development and discussion of principles and ideas concerning human rights and their advocacy. In conclusion, I want to make three general points about the value, perhaps, of international human rights law as a framework for addressing threats to the rule of law. The first very important point is that human rights are universal. They are not, and I think it's widely accepted now, that human rights are not a Western notion. They accord to all human beings in all societies, irrespective of citizenship, culture, politics, or religion. And the Universal Declaration on Human Rights, which grounds the modern international human rights law framework, is a universal instrument accepted around the world. And I think there is potential for human rights law to provide a neutral framework within which difficult and sensitive political issues can be discussed and debated and assessed in terms of this neutral legal framework. The second point is that international human rights law can help to address the argument, which is frequently made, that that interference with the rule of law is necessary to address some imperative public policy interest, whether that be the interests of security or the results of an economic crisis, etc. Because international human rights law has a very clear framework for when restrictions on particular rights may be permissible, which rights are never permitted to be restricted, and the circumstances in which rights can be derogated from in states of emergency. And it limits these kind of limitations and derogations extremely strictly. And the third point to make, which perhaps will come to some of the presentations by the other speakers, is that there is a system of enforcement and supervision of international human rights law, which it is important that needs to be supported by national implementation, but also needs to be used by all of us to make this international human rights law effective. Thank you.
Firstly, can I say thank you very much for that timely intervention. I'm now going to turn to Professor Osman Doğru, who has specialized in constitutional issues, in particular in relation to human rights. And I think you, Professor, now have 15 minutes until 12:40.
Thanks. Efendim, konu başlığımız temel hakların korunması. İki kavram, temel haklar ve koruma kavramları. Gerçekten bu iki konu hakkında da Türkiye'de açık veya üstü örtülü tartışmalar var. Pek akademik dünyaya yansımayan ama belki medya dünyasında kalan, bu terminolojiyle olmasa bile farklı terminolojiyle çok tartışmalar oluyor. Önce ben temel haklar üzerinde genel fikirlerimi söyleyeceğim. Ardından da bu temel hakların korunma konusuna, özellikle de Türkiye'de korunma konusunda bazı tespitler yapmaya çalışacağım. Temel hakların kaynağı konusundaki çatışma çok uzun bir dönemin çatışması. Doğal hukuk, pozitif hukuk çatışması bildiğimiz gibi. Doğal hukuk mu acaba temel hakların kaynağı? Antigone'ye, Sofokles'in eseri Antigone'ye gidecek olursak, evet, kralın koyduğu kuralların üzerinde de doğal yasalar var demişti. Artık 20. yüzyıla geldiğinde ve 20. yüzyılın ikinci yarısı ilerlediğinde biz bu karşıtlığın yavaş yavaş sona ermekte olduğunu düşünüyorduk. Çünkü gerçekten uluslararası alanda insan haklarının, temel hakların büyük bir kodifikasyon dönemine tanık olduk. Tabii bunun geçmişi çok uzun değil, belki pozitifleştirme, kodifikasyonun oluşumu. Ama önünüzde bir pozitif metin varsa, insan haklarının ne olduğunu söyleyen, bu konuda daha rahat edersiniz, daha uygulamaya dönük olarak hareket edersiniz. Kaynağı konusunda temel hakların ikinci bir çatışma. milli hukuk, uluslararası hukuk çatışması. Bu çatışmayı Avrupa düzeyinde veya evrensel düzeyde böyle mi, ona değinmek istemiyorum. Yani evrensellik ve kültürel görelilik konularına girmek istemiyorum. Buradaki sözünü etmek istediğim şey, milli hukuk, uluslararası hukuk çatışmasından bizim Twitter kararı. Yani Anayasa Mahkemesi'nin çok kısa bir süre önce vermiş olduğu Twitter kararı. Bu karardan hemen sonra Anayasa Mahkemesi'ne yöneltilen en büyük eleştirilerden bir tanesi bu kararın milli bir karar olmadığı. Bir kararın milli olup olmaması nasıl anlaşılabilir? Birincisi, bu kararın ardındaki hukuk milli hukuk değil. Veya ikinci bir yorum, milli menfaatlere uygun değil. Birincisi ise, yani milli hukuk yok ise, o zaman onun arkasında uluslararası hukuk var demektir. Zaten Anayasa Mahkemesi'nin işi uluslararası insan hakları hukukunu uygulamak değil mi? Nereden çıkıyor bu? Birincisi, Anayasanın 2. maddesinde insan haklarına saygılı devlet teriminden. İkincisi, 90. maddedeki uluslararası hukukun üstünlüğüne referans yapan hükümden. Üçüncüsü de Anayasanın 148. maddesindeki İnsan Hakları Avrupa Sözleşmesi kapsamındaki haklar ifadesinin açık açık yer almış olmasından kaynaklanıyor. Dolayısıyla milli hukuk, uluslararası hukuk tartışmasını biz yapıyoruz. Her ülke demek ki bu tartışmayı içselleştirerek devam edecek. İnsan haklarının, daha doğrusu temel hakların içeriği itibariyle baktığımız zaman bir liste var elimizde. İnsan Hakları Avrupa Sözleşmesi'nde, İnsan Hakları Evrensel Beyannamesi'nde, Medeni ve Siyasi Haklar Sözleşmesi'nde, Birleşmiş Milletler ve diğer belgelerde yer alan hak ve özgürlükler listesi var. Yaşama hakkından, ifade özgürlüğüne, adil yargılanma hakkından, mülkiyet hakkına uzanan uzun bir liste. Ama biliyoruz ki biz bu listelerde yer alan haklardan daha fazla, daha uzun bir müdahale listesi var. Yani bu hak ve özgürlükleri ihlal etme tipleri çok daha fazla. Ben hak ve özgürlüklerdense bu müdahaleler üzerinde konuşmaktan zevk alan bir hocayım, akademisyenim. Örneğin yaşam hakkı ile ilgili 90'lı yıllarda çok sayıda faili meçhul, gözaltında ölüm, gözaltında işkence, gözaltında kayıplar gibi olaylarla karşılaştık. Bugün yok. Şükür yok. Ama bugün de toplantı ve gösteri yürüyüşleri sırasında kafasına gaz fişeğiyle yaralanan çocuklarımızın, gençlerimizin ölümleri var. Çıkan gözler var. Yaralamalar var. Yani müdahale biçimleri değişse de sanki ve oranları değişmiş olsa da sanki ihlaller devam ediyor gibi geliyor bana. Evet, 1990'lı yılların çok önemli bir problemi uzun gözaltılardı. 30 gün, 45 gün Devlet Güvenlik Mahkemesi kapsamına giren suçlar bakımından gözaltılar uzundu. Ben öğrenciyken gözaltı süresi 90 gündü askeri rejimde. Dolayısıyla bize göre iyileşme vardı. Ama tabii ki uzun gözaltı demek aynı zamanda işkenceye davet demekti. Bugün ne mutlu ki hem gözaltı süreleri çok kısaldı ve gözaltı süreleri bakımından getirilen koruyucular artık gözaltında işkence konusunu sıfır olmasa bile belki sıfıra yaklaştırdı. Yapılsa bile karakollarda bir takım kayıtlar bulunabiliyor. Örneğin bir kadının karakolda dövülmesiyle alakalı bir video kaydı basına yansımıştı. Dolayısıyla bunlar tespit edilebiliyor. Bunlar iyi şeyler. Ama bazı şeylerde devam ediyor sanki. Gözaltında, karakollarda değil de cezaevlerinde başka sorunlar var tabii. Fakat gözaltına almadan önce yakalama döneminde hemen böyle otobüslerin karanlıklarının içine götürülen göstericiler ve orada kendilerine hakaret edilen insanlar ve darp edilen insanlarda olduğu basına yansıyor. Tabii bunlar yargısallaşmış konular değil. Adil yargılanma konusunda şükür Devlet Güvenlik Mahkemesi artık yok. Devlet Güvenlik Mahkemesi'nde askeri yargıç vardı. İnsan Hakları Mahkemesi Incal kararında bu adil yargılanma hakkına aykırı dedi ve kaldırıldı. Bundan memnunluk duyuyoruz. Ancak adil yargılanma hakkıyla ilgili başka ihlal iddiaları ortaya atıldı. Örneğin sahte deliller konusu, savunma haklarının kısıtlanması konusu gibi. Bunlar da henüz tam olarak karara yansımadığı için henüz daha bunlar üzerinde konuşmak erken gibi görüyor. Haklar listemiz uzun, bireysel haklar listemiz uzun ama ihlallerin listesi gerçekten çok daha fazla uzun. Haklardan daha fazla ihlal türleri var. Tabii ifade özgürlüğü konusundaki ihlalleri de geçemeyiz. Orada da hem Sayın Karakaş'ın az önceki konuşmasında belirttiği gibi link davasına referans da belirttiği gibi alınması gereken bazı tedbirler henüz alınmış değil. Şimdi bu hak ve özgürlüklerin tanınması konusu anayasalarda, uluslararası belgelerde hep oldu. Bizim 1924 Anayasası'nda da, 61 Anayasası'nda da, 82 Anayasası'nda farklı koruma rejimleriyle beraber yer aldı. Fakat gerçekten korundu mu? Ta ki önce 87 yılına kadar diyelim, ondan sonra da 2010 yılına kadar. 87 yılında ne oldu? İnsan Hakları Avrupa Komisyonu'na Türkiye bireysel başvuru yetkisini tanıdı komisyonun veya bireysel başvuru hakkı tanıdı. Ve böylece aslında Türkiye kendi fotoğrafını uluslararası bir alanda görmek için bir adım attı. Yani benim fotoğrafımı çekebilirsin dedi komisyona, İnsan Hakları Mahkemesi'ne. O kadar çok fotoğraf çekti ki Strasbourg organları çok yoruldular. Ve dediler ki biraz da kendi fotoğrafınızı kendiniz çekin. 2010 yılında yapılan anayasa referandumunda Anayasa Mahkemesi'ne bireysel başvuru hakkı tanındı. Bence gerçekten çok önemli bir devrimdir bu, sessiz devrimdir. Hatta işte Radikal'deki bir makalede bu şekilde nitelendirmiştim. Pek o zaman üzerinde tartışılmadı, konuşulmadı ama sonuçları zaman içerisinde görülecek. Şimdi o tarihte dendi ki veya denmekte ki aslında İnsan Hakları Anayasa Mahkemesi'nde bireysel başvuru hakkı bazı davaların İnsan Hakları Mahkemesi'nin önüne geciktirilmesi için getirildi. Yani Anayasa Mahkemesi'ne bir sorunları öteleme, geciktirme fonksiyonu yüklendi iddiası dolaştı. Bir bu var. Bir de Anayasa Mahkemesi cephesinden bakılacak olursa, Anayasa Mahkemesi de etkili bir başvuru yolu olduğunu kanıtlamak istiyor. Bunu yakından biliyorum çünkü bu 2 yıllık yani referandumdan sonra bu hakkın yürürlüğe girdiği tarih içinde Anayasa Mahkemesi'yle çok yakın çalıştım. Avrupa Konseyi'nin yüksek yargıyı güçlendirme projesi çerçevesinde Anayasa Mahkemesi'nde çok sayıda seminer yaptık. İş tüzük yapılması sürecinde fikirlerimi söyleme imkanı bulmuştum. Anayasa Mahkemesi'nin tabii ki etkili bir başvuru yolu olma kaygısı var. Ama bunu yapabilecek mi? Bir taraftan iç baskı diyor ki sorunları ötele. Çünkü siyaset gayet doğaldır. Benim sorumluluğumun ortaya çıkmasını istemem bir siyasetçi olarak. Ama öte yandan mahkeme kalıcı ve ayakları üzerinde durmak isteyen bir kurum. Yani her şeyi şekillendiren bir kurum değil tabii Anayasa Mahkemesi ama devamlılığı sağlamak, hukukun sabahtan beri veya dünden beri konuşulan hukuk güvenliğini, istikrarı sağlamakla yükümlü. Bunun araçlarından biri Anayasa Mahkemesi. Bu ikisi arasında zannediyorum etkili bir başvuru yolu olmak ile geciktiricilik fonksiyonu arasında Anayasa Mahkemesi biraz gidip gelecek gibi geliyor bana. Anayasa Mahkemesi peki nasıl bir pratiğe sahip? 250 civarında karar verdi bugüne kadar. Bunların çoğu kabul edilemezlik kararı. Gerçekten kabul edilebilirlik şartlarını çok dar yorumluyor Anayasa Mahkemesi. Dolayısıyla başvurucuların bana göre haklarını da bu anlamda dar yorumlamış oluyor. Kabul edilebilirlik şartları bakımından bir örnek vermem gerekirse Onurhan Solmaz. Onurhan Solmaz bir transseksüel. İzmir'de yaşıyor ve İzmir'de bir gazetede bir yazı çıkar. O yazıya göre İzmir'deki transseksüellerin polis tarafından temizlenmesi çok iyi olmuştur. Bu özellikle 2020 Expo mücadelesi sırasında polisin bu transseksüelleri temizlemesi, ortadan kaldırması, sürmesi çok iyi olmuştur şeklinde transseksüelleri, eşcinselleri aşağılayan bir yazı çıkmıştır. Başvurucu da yerel mahkemeye başvurarak demiştir ki benim hakkım ihlal edildi. Hangi hakkım? Özel yaşama saygı hakkım. Daha doğrusu mahkemeye değil savcılığa başvurmuştur. Savcılık da bir soruşturma açmıştır yazar hakkında. Demiştir ki kin ve düşmanlığa tahrik, işte farklı cinsiyet grupları arasında insanları tahrik eden bir yazı bu demiş. Bu konuda bir soruşturma açmış ancak sonuçta ifade özgürlüğü yönünde karar vermiş savcı ve takipsizlik kararı vermiş. Anayasa Mahkemesi'ne başvurmuş. Bireysel başvuru yapmış bu başvurucu ve Anayasa Mahkemesi konuyu özel yaşama saygı hakkı yönünden yani hakarete uğramama, aşağılama yönünden değil ama adil yargılanma hakkı yönünden inceleyip bu başvuruyu adil yargılanma hakkı ile ilgili bir problem yok diyerek karara bağlamış. Şunu demek istiyorum, Anayasa Mahkemesi'nde henüz daha insan hakları duyarlılığı galiba yavaş yavaş oluşacak, eleştire oluşacak diye düşünüyorum. Tabii bir de ikinci bir şey daha var. Hazır 2 tane İnsan Hakları Mahkemesi yargıcını burada gördüğüm için acaba biraz daha Anayasa Mahkemesi'nin vermiş olduğu kararlardan sonra yapılan başvurulara öncelik verebilirler mi? Biz de bir an önce Anayasa Mahkemesi'nin fotoğrafını, performansını görmüş olalım. Teşekkür ederim.
Thank you very much indeed, and that's a perfect segue to Professor Lemmens as European Court Judge.
Yeah, wait. Get rid of this here. Yeah, thank you very much, Madam Chair. And ladies and gentlemen, let me also, like most of the other speakers, thank the organizers, but also congratulate them for taking up their responsibility, the responsibility of the whole bar, I would say, in looking at difficult times or in difficult times when justice and rule of law are in trouble. I think it's a very good initiative. I would like to say something about human rights protection at the domestic and the European level. I will look at the two systems of protection from the point of view of the European Convention on Human Rights and from the point of view of the European Court of Human Rights case law. I will do that in my personal capacity. I cannot say that whatever I'm saying here, that this is representative of the European Court, and my colleague Ishil will certainly agree with that. My approach will be based on the idea of the shared responsibility as it has been expressed many times by our own court. And I quote from a recent judgment, "By virtue of Article 1 of the Convention, the primary responsibility for implementing and enforcing the guaranteed rights and freedoms is laid on the national authorities. The machinery of complaint to the court, the European Court, is thus subsidiary to national systems safeguarding human rights." And this subsidiary character is articulated in a number of articles of the European Convention. In the future, this subsidiary character of the European protection and the primary responsibility of the national protection will be part of the preamble of the European Convention on Human Rights. That preamble will be included in the preamble. That new paragraph will be included in the preamble through a new protocol to the European Convention, which has already been adopted last year, but which is awaiting ratification by all 47 member states. Now let me start with the human rights protection at the domestic level. Primarily a role for domestic courts. And this is a fundamental guarantee in itself, the right to an effective remedy at domestic level. The court has had many times to deal with the question whether or not individuals did have such a right, whether they could bring human rights complaints before a domestic organ that offered an effective remedy. An effective remedy means that there's a possibility to bring a complaint before a body, that body is able to deal with the complaint, and that it is also able to grant appropriate relief. Effectiveness does not mean that you necessarily win your case. It means that the organ competent to examine the complaint has sufficient powers to grant relief, and that the procedure offers also sufficient guarantees. And above all, it should be an independent body. Therefore, preferably, but not necessarily a judicial body. And as a last element, I would also like to say that the effectiveness depends on the speediness of the remedy. It is not inconceivable that the adequate nature of a remedy can be undermined by its excessive duration. Now, on the one hand, you have this right to an effective domestic remedy. On the other hand, if there is such a domestic remedy, it helps the state. Because then there is another requirement in the convention that says before you can complain to the European Court, you have to exhaust the available domestic remedies. So this admissibility requirement for applications to the Strasbourg Court is based on the assumption that individuals do enjoy in the national system the right to an effective remedy. Why is there this admissibility requirement? In order to make it possible for the domestic authorities to put matters right through their own legal system. The obligation to exhaust domestic remedies means in essence two things. You must go through the national system, if necessary, all the way up to the highest court to exhaust the domestic remedies. And secondly, and this is sometimes forgotten, you must also invoke fundamental rights while you are doing that. You cannot say at the end of the whole domestic proceedings without having thought about human rights, oh, and now there is still Strasbourg. Well, then it's too late. You must have thought of fundamental rights, not necessarily those of the European Convention, perhaps those of the domestic constitution, but you must think about them and even more invoke them before you will be able to make a complaint to the European Court. There may be sometimes circumstances that absolve an applicant from the obligation to exhaust domestic remedies. For instance, when it's clear that you have no chance of winning your case when you are going to appeal. If there is a clear case law, you should not do as others and get a judgment that clearly will be unfavorable to you. It could also be, Ishil has already pointed to that proceedings, and I've also repeated it already, that effective remedies are no longer effective because of the long duration of the proceedings. Now let me turn into the situation in Turkey. And our colleague has spoken about the Constitutional Court under its new powers. And this mechanism has already been evaluated by the European Court in Strasbourg, and more specifically by a decision of 30th of April of 2013 in the case of Hasan Uzun versus Turkey. It was the first time that the Constitutional Court mechanism came before our European Court. And the European Court examined whether the remedy, the domestic remedy, was accessible to individuals. The answer was yes. Whether the Constitutional Court had enough powers to effectively examine complaints. Yes. Answer was again yes. It also examined what the scope of the Constitutional Court's competence was, and it found that the court could examine whether there had been a violation of fundamental rights, and that it could also provide redress. Specifically with respect to violations committed by judges, it could decide that the case had to be reopened, or it could also decide that compensation be awarded. The European Court also found that the number of judges serving at the Constitutional Court seemed sufficient to deal with the number of applications. That, of course, remains to be seen whether this is still the case and whether the Constitutional Court will not, like the European Court in Strasbourg, become a victim of its own success. And finally, the court in Strasbourg said about the scope and the effect of the Constitutional Court's decisions. These decisions are binding. They should be respected by all authorities in the country. And a priori, there is no question that this will not happen, because in the past, Constitutional Court judgments have been respected, even in politically sensitive issues. So the conclusion was, at that time, this is an effective domestic remedy, and it must be exhausted before individuals can come to the European Court in Strasbourg. Mr. Uzun had not done that, and therefore his application was declared inadmissible. But after having said that, the European Court added a word of caution. This is only a provisional evaluation. The court emphasized that it retained its ultimate power of review in respect of any complaints submitted by applicants who in the future would have gone through the Constitutional Court procedure, and it then reserved the right to examine the consistency of the Constitutional Court's case law with its own case law to conclude whether or not the Constitutional Court indeed provided an effective remedy. This is a very important development, this constitutional court mechanism here in Turkey, and I will come back to that in my conclusions. Let me say something, secondly, about human rights protection at the European level. And I don't think that I should say too much about the role and the competences of the European Court of Human Rights. I would just like to underline that the European Court exercises a judicial supervision. Its task is not to take the place of the competent national authorities and to decide the claim, the original claim, anew, but rather, and I would say simply, to review the decisions that have been taken in the light of the European Convention. Nevertheless, I will of course not deny that this role of the European Court is not an essential one, or that the role is an essential one. In individual cases, the intervention of the European Court can be highly important where domestic courts have not done their work properly or where their decisions have not been properly implemented. And on a more general level, the European Court's interpretative role is important. The role of the European Court is to set up pan-European standards, minimum standards applicable in all 47 member states. And Roisin has indicated to the fact that human rights standards provide a neutral framework. I think that is very important. It is not a local court that may be subject to all sorts of influences that sets up standards. It's a European court far away from the political disputes in individual countries that decides what are the pan-European standards. I would like to say that the European Court, of course, has handed down many cases that might be relevant for our discussions here on the situation in Turkey. As a judge of the European Court of Human Rights, I have a sort of obligation of reservation, and I find it inappropriate to express an opinion on what is currently going on in Turkey. But I looked at the case law of the European Court, and I found a number of cases, there are many cases, that could be relevant for the situation. And I would just like to go through a number of cases without many comments. A case, Sovtransavto Holding versus Ukraine, first on the independence of the judiciary, which involved proceedings before a commercial court. It was in Ukraine, involving a Russian company, which was the applicant company before the European Court. And the European Court noted that there had been numerous interventions by the executive, including the president, to the courts, the domestic courts, urging them to defend the interests of Ukrainian nationals. The European Court found a violation of Article 6 on the right to an independent court. Secondly, a case against Russia this time, Kudeshkina versus Russia, about a judge, a person who was a judge for more than 18 years, and who was appointed to sit as a judge in a high-profile case concerning abuse of power of a police investigator. And at a given moment, this person, this judge, was removed from the case. She complained to what we would call the High Judicial Council about pressure put on her by the president of her court. That complaint was dismissed, and to the contrary, disciplinary proceedings were started against her, which ended in her being removed from the judiciary because, in the meantime, in 3 interviews, she had criticized the political manipulation of courts. The European Court found a violation of that person's right to freedom of expression, and I would like to quote something from the judgment. Where is it? Yes. Her interviews referred to a disconcerting state of affairs and alleged that instances of pressures on judges were commonplace, and the court said she said that this problem had to be treated seriously if the judicial system was to maintain its independence and enjoy public confidence. And this was one of the main elements for the European Court to find that this was a very important issue of freedom of expression. Then about the neutrality of civil servants and public services, a judgment of 2008 in the case of the Georgian Labour Party versus Georgia, about a political party that participated in the parliamentary elections, that did not get enough votes to get over the threshold, therefore was no longer represented in parliament, and then complained to local election commissions. And the European Court found, of course, the complaints were dismissed. Afterwards, there was then the application to the European Court. The European Court found that the possibility to obtain redress at the domestic level was in fact not a real one because of the composition of these electoral commissions, where there was a clear majority of people who had direct links with the existing government, the government in power, and the majority party. And the court found that this was a violation of the right to be elected. And it's interesting to note that in this court, in this judgment, the court also said that it has often underlined the necessity to maintain the political neutrality of those civil servants, judges, and other persons in state service who exercise public authority, so as to ensure that all citizens receive equal and fair treatment that is not vitiated by political considerations. I don't have to mention cases about criticism by journalists, by opposition parties in the area of political speech or debate. There are numerous judgments, including, for instance, criticism on heads of state or government, where the European Court has always emphasized if you are in politics, you should stand criticism. If you cannot stand it, if you can't stand the heat, stay out of the kitchen. And especially also, if you are in power, you should exercise restraint in reacting to criticism. Do not, for instance, use the criminal system so that criminal sanctions are imposed on those who criticize political action. Peaceful demonstrations, also a number of judgments about reactions to demonstrations. Because of the lack of time, I will not get to it. I would like to just indicate that very recently a case relating to demonstrations has been referred to the Grand Chamber of the European Court of Human Rights. That's was about farmers in Lithuania who had blocked major roads during 3 days. There was a dispute with the government on farming prices, on agricultural products, about the price of agricultural products. Finally, they got a settlement with the government, but then afterwards, the government put in motion the criminal mechanism, and those who had participated in the blockade were convicted, and they received custodial sentences, which later were suspended. And here again, the Chamber of the European Court found that the authorities should have shown a bigger degree of tolerance towards the disruptions during protests, and that criminal proceedings were not a proportionate response. The Chamber found a violation of the freedom of association, but it was with a majority of 4 against 3, and this is probably also one of the reasons why the filtering panel of the Grand Chamber has decided to accept this case for a review by the Grand Chamber. I could go on and on, but we do not have the time. I would like to come to some conclusions. An effective judicial protection is not only a requirement under human rights law, in particular under the European Convention on Human Rights, it's also an important element of the rule of law. And the European Court itself has developed quite some ideas on what the rule of law is. applicable to the legislature, the executive, and also to the judiciary and the functions of the judiciary. What has the European Court said about the rule of law? For instance, that the rule of law implies a right of access to courts for adjudication of disputes, including disputes with public authorities. It implies structural and procedural guarantees, in particular judicial independence and separation of powers. And finally, it implies a respect for the binding force of judgments, a right to obtain the execution of judgments. The effectiveness of the protection of human rights depends, as I've said in the beginning, in the first place on the domestic courts. And in Turkey, this means in a very special way on the Constitutional Court. The decisions of the Constitutional Court, however, remain subject to the European supervision by the Strasbourg Court. I would like to say that both courts, the Constitutional Court and the European Court, serve the same purposes and can mutually reinforce each other. The Constitutional Court can reinforce, can help the European Court by setting things straight at the domestic level. I do believe that the European Court can assist the Constitutional Court by offering its supranational guidance as to the interpretation of fundamental rights. I read the speech given by the President of the Constitutional Court some weeks ago, in which I saw and read an expression of a deep commitment to the cause of human rights and of a sense of responsibility of the Constitutional Court vis-à-vis Turkish citizens. And in this sense, I feel very much sympathy for the Constitutional Court, and I wish it firmness, wisdom, and undoubtedly also some creativity. Thank you.
Well, I want to thank our three contributors very much because, of course, we've had the general, the specific in relation to Constitutional Court, and last not by no means least, the European Court of Human Rights. I think I've been told that we now have perhaps another 10, 15 minutes for us to just have a discussion about some of those issues that have been raised this morning. So I hope that I'm not going to deprive too many of you of your lunch, and I hope this period will enable you to have a contribution to the debate. We've been asked 4 questions from the audience so far, and I'm just going to address them to each of our 3 speakers to see which wants to make a contribution, although a number of them have been directed both at me and at Judge Lemmens, but I take into account the strictures that he indicated just at the end of his remarks, that a degree of specificity in relation to Turkey may not be entirely wise. The first question that we're asked is, international human rights text places obligations on states not only to respect fundamental rights and freedoms, but also to take measures to prevent violations and assure a protective environment. It means in modern theories of human law, states are not supposed to be inactive with respect to human rights. Accordingly, how can states be impelled or obliged to take action by international organizations, NGOs, and the national and international community to take necessary measures in an effective manner? I don't know who wants to go first on that, maybe Roisin? As an NGO.
Well, it's a very big question, and it's a very practical question, I think, which is a good thing. Well, I think the first point is that this is a matter of national implementation, which needs to be addressed at a national level by all of the different actors, for the public authorities, for the executive to understand the full extent of their responsibilities, to take positive measures to prevent violations, to protect against violations. It's extremely important that those positive measures be put in place for obligations under the European Convention and other instruments. Civil society has an important role at a national level in holding government to account for those obligations, I think, through persuasion and advocacy with government. And then lawyers, of course, also have a responsibility through litigation of these issues in the national courts. So this is it's a collective exercise, I think, for a society to hold government to account within the national system for the full range of its obligations to protect human rights. Then, of course, there are the international mechanisms, but they're very much the second step. But there is also, I think, a role for civil society, for the legal community, in the international supervision processes that there are, not only the European Court, of course, but also the periodic reviews by the United Nations treaty bodies, for example, the special procedures, such as the Special Rapporteur on independence of judges and lawyers, but she is only one of the many special procedures that exist in the United Nations to supervise the respect, the protection, and the fulfillment of states' human rights obligations. And these are all processes in which civil society can engage and the legal profession can engage to provide their analysis of how governments have fulfilled their obligations.
Thank you. And Professor?
Tabii ki ulusal sistemin güçlü olması İnsan Hakları Mahkemesi'nin işini kolaylaştırır, ona az iş yükü yükler. Sivil toplumun güçlü olması, ulusal kurumların güçlü olması, daha doğrusu ihlalin çıktığı yerde yok edilmesi çok daha önemli, çok daha güçlü bir sonuç doğurabilir. Ben örneğin 1990'lı yılların ortasında Türkiye'de bir milletvekili hatırlıyorum. İçişleri Bakanı'nın önüne gidip bir pankart açmıştı. Dedi ki bu iş yerinde işkence var. Ve kamuoyu ona döndü. Nerede işkence? Aslında herkes biliyor karakollarda, cezaevlerinde işkence olduğunu. Nerede işkence diye söylediler. Manisa çocukları olayı ortaya çıktı. İşte Manisa'da genç yaştaki insanlar gözaltında işkence edilmişlerdi. Duyarlılık oluştu böylece. Milli sistem her zaman tabii ki etkili olabilir fakat herkesi koruyucu olamayabilir. Dolayısıyla uluslararası sisteme, uluslararası asgari standartlara zannediyorum daima ihtiyaç var. Çünkü milli sistem içerisindeki bazı güçlü gruplar kendi isterleri doğrultusunda bazı hak ve özgürlüklere ağırlık verebiliyorlar. Onların korunmasına ağırlık verebiliyorlar. Ama uluslararası sistem, tabii ki milli sistem de böyle olmalı. Uluslararası sistem zannediyorum daha objektif ve herkese eşit muamele edecek şekilde baktığını söylemek mümkün gibi geliyor bana. Evet.
And Professor?
Yeah, I would just like to add something about the possibility of an international control on whether domestic authorities have taken measures or not, the positive obligation issue. And I would like to do that by referring to a judgment that I have not yet referred to, a judgment against Turkey, which was handed down last year on the 16th of July in the case of Abdullah, Yasha and others. This was about demonstrations that had taken place in Diyarbakir, where violence was being used on the two sides. Police used tear gas, and the applicant, then 13 years old, was injured in the head by a tear gas grenade. He brought, in the end, an application to the European Court, which found that tear gas was not simply being used, but tear gas grenades were launched at the demonstrators. And the court found that after having analyzed all the elements of the case, that it was not established that the use of force against the applicant had been an appropriate response to the situation in the light of the requirement not to apply ill treatment to individuals. That's about an interference by the domestic authorities in the rights of an individual. But the court went on, and it then spoke about the positive obligations of the Turkish state. And it noted that at the time of the events, I'm quoting from the judgment, Turkish law lacked any specific provisions governing the use of tear gas grenades during demonstrations and did not lay down any instructions for their utilization by the police forces. The court notes that in the meantime, a circular setting out the conditions for the use of tear gas was issued by the Director General of Security. Nevertheless, the court considers it necessary to reinforce the guarantees on proper use of tear gas grenades in order to minimize the risks of death and injury stemming from their use by adopting more detailed legislative and/or statutory instruments. It was mentioned by the court in the part dealing with the execution of its judgment. It is about prevention of further violations in the past through the setting up of a sufficient legal, legislative and regulatory framework. And that's about positive obligations. This follows from the judgment of the court. Supervision of the execution of this part of the judgment is in the hands of the Committee of Ministers of the Council of Europe. And so here I think that international human rights law and international supervision can also contribute to respect to the fulfillment of positive obligations of states.
I think I'm afraid we are running out of time, so with everyone's permission, I'm going to merge the 3 questions remaining into one, and if I can ask comments to be as crisp as possible, because I think otherwise our audience may give up the will to live. The 3 questions are really these. There's concern being expressed about the number of Turkish officials, high-level ones, judges, governmental institutions, people who've been removed from their office without any form of process, it is alleged. And secondly, there's an issue about how you preserve the minorities' will against the majorities. How do you make that balance? And the last is, since Turkey is a party to the European Convention on Human Rights and is bound by its provisions, what do we do about the fact that it's thought by some that Turkey is non-compliant with ECHR decisions, and are there measures that can properly be taken in order to oblige compliance? So 3 questions, almost impossible to answer, and you have about 60 seconds each. Don't know who wants to go first.
Okay. HSYK sorunu yargıçların durumu. Ama orada yargıç tasfiyesi olmadı HSYK'da. Sadece çalışanların, yani sekreteryasındaki kişilerin görevden alınmaları, değiştirmeleri söz konusu oldu. Zannediyorum 2010 referandum ile kazanılmış olan veya yapılmak istenen şeyden bir geri adım olarak değerlendirmek mümkün bunu ve belki ileride bunun bağımsızlık ve tarafsızlık bağlamında çok daha sorun yaratacağını görmek mümkün. Ama bence bir önemli şey daha var. Birkaç ay sonra, yani zannediyorum Eylül veya Ekim ayında HSYK için yapılacak seçimler. Onun ikincisini atlayayım. İnsan Hakları Mahkemesi kararlarının icrası ile ilgili Türkiye neden uyum sağlamıyor? Uyum sağlaması isteniyorsa İnsan Hakları Mahkemesi'ne Türkiye'nin bu kararlara uyum sağlaması isteniyorsa Galiba bir 46. maddenin 3. ve 4. fıkrasını Türkiye'ye hatırlatmakta yarar var. Yani siz mahkemenin kararlarına saygı göstermiyorsunuz şeklinde bir mesaj göndermekte yarar var. Tabii bu bir politik süreçtir ama bu madde, bu hükümler hiç uygulanmadı. Hiçbir ülkeyle ilgili bildiğim kadarıyla uygulanmadı. 60 saniye.
Professor, I'm going to turn to you next.
Yes, I will be very short on the three questions. About the removal from office of judges and prosecutors, I do not have to add much to what I said already. There is enough case law of the European Court of Human Rights that indicates that individual judges can invoke violations of their fundamental rights, freedom of expression perhaps during the process, the right to a fair trial, in cases of removal from office. I'm not going to say anything about the current situation. Second, protection of the minority against the majority. It's interesting that this question is being raised. I would like to note that in the case law of the European Court, there is very often a reference to a wording in the convention that is the democratic society, because interferences with human rights can be justified only if they are necessary in a democratic society. And what characterizes a democratic society is not so much that you have rules that make it possible for the majority to win always because it has the majority in parliament. What characterizes a democratic society is that all people have their place in a society and that there is also respect for the minority, which means that you have to have dialogue rather than imposing the will on a minority. Finally, about non-compliance of Turkey with judgments of the European Court of Human Rights. Turkey is not the only country that has some problems with complying with the judgments of the European Court. And as you have indicated quite rightly, there is Article 46 of the Convention, which gives the power to the Committee of Ministers, I've also already spoken about that, to control in each case whether the national state has taken the measures to execute a judgment of the European Court. It's a sort of a political peer review by governments among each other. But this is in fact not the only thing. It's the main competence is within the Committee of Ministers, but of course it is possible that another applicant in a new case will bring a similar complaint to the European Court of Human Rights. And then, although the European Court will have to examine that new complaint and give a judgment on that new complaint, it will be clear from its judgment whether or not there has been an improvement compared to the first judgment and whether that judgment has been executed. The court cannot do more. It does not have a police corps at its disposal. It is not the European gendarme, but it can simply indicate implicitly that maybe a judgment has not yet been executed.
And last but not least, Roisin.
I will be very brief if I can. The first question I think has already been well addressed. The second question regarding protection of minorities, I would just note that I think this has been one of the great successes of the European Court, is the jurisprudence that has developed on the protection of various vulnerable groups, and there is often a blind spot in national systems on one or more minority or marginalised groups, and the court's jurisprudence has been particularly important in this regard. But bear in mind that there are also other treaties. There is the UN Convention on the Elimination of Racial Discrimination, for example, and the Convention CEDAW on women's rights. There are a number of other treaties that also protect against discrimination against particular groups. The question I want to address in a little more detail is indeed in regard to the execution of judgments of the European Court. I think, as Professor Lemmens said, that this is a problem throughout the whole Council of Europe region, and it's certainly recognised now that one of the issues needing most attention, I think, within the European Convention system is making execution of judgments more effective and more reliable. But I think it's important to point out that there is both a national aspect to this and a supranational one. It is the Committee of Ministers that is responsible for the supervision of execution of judgments. But the execution of the judgment itself is a process that takes place nationally. And I think a lot can be done in putting in place a national system following a judgment of the court. There should be a process that takes place once there is a judgment against the state that allows the national system itself to see what measures are needed for implementation, what general measures, whether there is a need for new legislation, for example. And that is a process which, at its best, should include the Parliament, should include civil society, should allow for the government to receive submissions from concerned people, from civil society, as to what measures should be taken. And there should be a predictable process which then can result in effective and full implementation of the judgment at a national level before it even comes to supervision in the Committee of Ministers.
Thank you very much. Well, can I thank each of my speakers for rapidly responding to those challenging questions and invite you all to have a splendid lunch. I can assure you that when you come back from lunch, I will try to be crisp with my intervention so that I don't detain you for very long. Thank you very much.